The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
This morning we have 3 cases for submission. The first case is State of Iowa versus Majors. The second case is Thornton versus American Interstate Insurance Company. And the third case is Campuzano versus Polk County District Court. The third case is non-oral and is deemed submitted at this time. And we're ready for the arguments in State versus Majors. Mr. Bender?
May it please the court. Good morning. As I was preparing this argument for the last week, I am reminded of the famous words of Yogi Berra, it's deja vu all over again. It's almost 3 years to the day I stood before this court and I argued that Mr. Majors, when he was resentenced, the district court abused its discretion when it misapplied the Lyle factors. This court ultimately agreed with that assessment and remanded this case back for another resentencing hearing. This court specifically concluded that the district court failed to consider the relevant factors. It improperly gave weight to other factors beyond those described in Robbie. Mr. Majors' prior case was decided on the same day as State v. Robbie, and this court specifically mandated on remand that this court is to apply those sentencing factors that were described in State v. Robbie. Mr. Majors contends on this appeal that the district court failed to follow the mandate of the Supreme Court on remand. Specifically, once again, Mr. Majors is arguing that the court misapplied and did not properly apply those factors as described by State v. Robbie.
Did the state have an expert in the first resentencing? Isn't that one difference? That after the mandate in the first Major's opinion by our court, the state used a psychiatrist and made a record through expert testimony, right?
Yes, you are correct. The 2 sentencing hearings are totally different. In the first hearing, it was just basically exhibits that were admitted, arguments by parties, and the court made a determination based on what it perceived as was the Lyle factors. In this case, Mr. Major admits that the district court did attempt to try to follow the State v. Robbie analysis. Specifically, the state relied on Dr. Clemens as an expert witness to provide some knowledge to the court on each of these factors. But I think, Mr. Major's position is, and I think the record does support this contention, is that Dr. Clemens is not qualified or was not qualified to provide the analysis that was needed and explain to the court as required by State v. Robbie.
But your client did not want to have an expert on his own behalf, correct?
Yes.
He waived that. So I'm imagining that, let's say the lawyer, your client still wanted no expert, and the lawyer thought, no, that's not good. I'm going to get an expert. So he went ahead and got an expert and had the expert testify. Same outcome. Wouldn't we be here again for another ineffective assistance of counsel? Isn't that lawyer kind of damned if he does, damned if he doesn't?
Well, I think if you look at what State v. Robbie stated, an expert should have been done for Mr. Major.
Isn't that burden on the state to provide an expert?
I think if you're a criminal defense attorney, if you're looking at what we started with Lyle, when we went to Seats, Sweets, White, Taylor, and all these cases, I think it's clear, if you're going to be an effective criminal defense attorney in this state, you better have your own expert witness examining your client and presenting that testimony in a trial.
Don't you think we'd be here if that lawyer vetoed what his client said? Isn't that a problem as well? I think there's a record made with the judge as well on his waiver.
I think if you look at this case here, his attorney waived the use of an expert witness at the hearing. But the district court provided the attorney out. Says, we'll keep the record open. Still have your client examined. Submit that report to this court. And the attorney still stated no. Now, I understand that there was a large delay in getting Mr. Majors back in for a resentencing. But the same token, when we have a mandate here that says that in order to really understand each of these factors, we have to have expert witness testimony. And if you look at Dr. Clemens, she's never dealt with juveniles in any setting outside of the adult correctional facility. She normally testifies at civil commitment hearings. She, in this case, if you look at what she did in this case, she never provided any assessments to Mr. Majors. It was just one interview. She never administered any psychological tests, any validated assessment, risk assessments. She never contacted any school officials, did not review any school records, did not contact the parents, did not talk to the parents, did not talk to friends. And the most alarming is she didn't review the transcripts. And she didn't even review all of DOC's reports in this case.
Isn't that all fair game for cross-examination, and doesn't that just go to the weight of her testimony?
But the district court relied on her as the expert. And if we're talking about whether or not the court properly applied these factors, and I think the most alarming is if you look at it, the court and the expert in this case was perceiving Mr. Majors through the adult lens. It was not perceiving him through the juvenile lens.
Well, at the second resentencing, he's, what, age 33, right?
That's true. He's been in prison a decade and a half.
Was it appropriate for the district court on resentencing to consider his prison disciplinary record?
When we look at the juvenile resentencing, we have to look at first, I believe, and I think it's the most proper way, is when he committed the crime. What's in his mental state at that time? And then we can take into account what he has done in prison. But the same token...
I mean, and this gets down to what we're looking for under Lyle and Roby. I understand with the life without parole, the U.S. Supreme Court said irretrievably corrupt or whatever that phrase is. But if we're talking about a mandatory minimum that here would still release him in his 30s, what are we looking for? What is the standard? What's you've talked about the evidence that should have been considered by the expert, but what's the ultimate issue that we're driving at here? Is it the circumstances of the crime, or is it his
if you're asking
capacity
me,
for rehabilitation?
I think based on the teachings of all these cases, I think it's clear. We look at the individual itself at the time of the crime. We look at whether or not they have afforded the ability to be rehabilitated and be a productive member of society. Yes, we're not talking about life without parole here. This is a 25-year sentence, with a mandatory minimum. He's going to go back into the community someday. And, we do have to take into account all the circumstances.
When is he eligible for parole if this sentence stands?
As a record right now, it's not in the record, but from my calculations, this mandatory minimum is either up or will be up very shortly. Because this crime occurred in, I believe, 2002. He was sentenced in 2003. So therefore, you just do the math. As long as he didn't lose good time in any of these, any disciplinary report, he'll be up shortly. But going back to what Justice Waterman was talking about, the disciplinary report, if you look at what Mr. Major's been afforded since he's been in prison, it's been one thing. You're talking about a decade and a half, he's only been afforded one opportunity to get his GED. He's been not afforded any substance abuse treatment. He's not been afforded any victim counseling or victim crime counseling. And we know from based on this record, he's been drinking alcohol since he's been 13. He was doing drugs, marijuana, cocaine, or meth, whatever it was, around this time of this incident. But he was never been afforded the opportunity. Well, it's once 2014 came when he saw that he possibly can get out of prison based on Lyle. He changed his behavior. And Dr. Clemens even testified that. Since 2014, he has done what's been required of him. But he still has not been afforded the opportunities that one would expect. Because at the end of the day, Justice Mansfield, these people in Mr. Major's circumstance will be back into this community. And the goal is to prevent recidivism.
Did he fake a urinalysis the day of his resentencing at age 33? Wouldn't that yet another discipline violation?
I'm not quite sure exactly when the fake of the year analysis, but there was a fake of the year analysis. But I think that goes to the fact that I think, if you look at what has, on the U.S. Supreme Court side, Graham and some of our other cases here on the juvenile behavior when they're put in a prison setting, he's only known, he's been in prison almost the same exact he's been out of prison. So, and he's been around adult criminals who's teaching him, unfortunately, things that we don't want him to be taught. But when we're talking about when juvenile resentencing, we have to be mindful of one thing, and I think it underscores everything that we talk about here, and I think what drives what we need to do here. We need to have the mindset, and the court has to have the mindset, the experts and all the parties involved. These juvenile offenders are savable. That's why That's why mandatory minimums are not the presumption. Because the idea is that, due to their immaturity at the time of their offense, due to the lack of skills that they had, that the brain development wasn't the way they were, that they made a mistake. And Mr. Major clearly exemplifies that in his circumstance.
But what would the state have to show to impose a mandatory minimum?
Well, I think in this case, every case we have before in this juvenile sentencing are forcible felonies because they have mandatories. So you can't rely on the crime itself to justify that, a mandatory minimum needs to be imposed. Because we're here for one reason, because they committed a heinous crime.
But, following up on what Justice Waterman is asking, and I think I was asking this earlier, a problem I have with the jurisprudence on the mandatory minimums as applied to these sentences that are much less than life without parole is what are we ultimately looking for? What does the state have to establish to get the court to impose a mandatory minimum? I understand what they can't do, but I want to know what's the threshold they would have to show.
Well, I think if we start looking at the factors here, you have to show, pretty much somebody who committed the crime, that they're well beyond their years when they committed their crime. This was not as a result of their juvenile behavior, but rather somebody who's adult, mature behavior. I think that's really the key here. I think that's really, if you're looking at it as a threshold question, where the path begins, where do we divert the path? You have to look at the individual at the time they commit the crime and see exactly where, in their mental state, where they were. Because if they really were a juvenile, behavior exhibiting during the crime, we should not be imposing the mandatory minimum because they are savable, they should be rehabilitated, enter back in. But those who are mature, who knows what's going on, they have that, as what, the Robbie court has stated with respect to the age, what we look at, when we analysis that. I think that's the threshold. I think that's why that's factor one. I think, if you look at these factors, there's a reason why we list them as they are. I think the significance of them is based on how they are presented. And I know it's difficult when we're talking about this versus someone who's serving life. But the same token, we treat all juveniles offenders should be treated the same.
I thought in your brief, at least, that you said that was an impermissible consideration, that would be taking age as an aggravating factor. And specifically this defendant, if I understand it right, was, 2 weeks shy of his 18th birthday?
What I said in my brief,
is that right?
What I said in my brief, yeah, he's 15 days short of 18. And what the court basically says, he's 15 days short of his birthday, therefore it's plausible to assume he's mature as an 18-year-old, so therefore age is not a mitigating factor.
Yeah, I get that. But let me get back, if you don't mind, to this expert business. What does the record show specifically on the role of the client when the court kind of held open the record? As I understand it, the court kind of held open the record and said, hey, and kind of made a second opportunity, if you will, to hire an expert. What does the record show as to the consultation with the client at that stage? Anything.
be quite honest with you, I think the record's pretty devoid of what was stated at that time. I think what we have is basically what's in the transcript, which is no, we're just going to proceed.
Okay, so that I mean, I probably suggest there was no consultation.
Yeah.
But and then on the question of the client not wanting to have an expert ab initio at first, what does the record show on that issue?
When he did the initial one, I mean, from my understanding, what the review of the transcript shows is that his attorney stated that they wanted to avoid any more delay, and they're waiving the use of the expert.
It's an attorney statement, and that's
Attorney
it.
statement.
Okay.
Wasn't there also a colloquy where the court addressed Mr. Majors directly and confirmed it was his decision?
I haven't reviewed that transcript specifically, detail. I believe there was somewhat of a discussion with Mr. Majors, but it was his attorney who put forward that they're waiving. It was his attorney who then waived the, with respect to having the record held open. And I think as an attorney who, I know my time is expired, if you allow me to answer.
Go ahead, answer and sum up.
If the teachings of Roby is we have to have an expert, then the attorney should be making a record that, we need an expert in the client's doing this against my advice. That was not done in this case. Thank you.
Thank you. Mr. Sloven?
Thank you, Your Honor. May it please the court, counsel. On the facts of this case as reflected in the transcript, there's a colloquy at the beginning of the resentencing hearing where the defendant himself, after being walked through a colloquy by his attorney, the defendant specifically says that he does not want any more continuances. He's aware that an expert could be appointed at state expense. He specifically wants no more continuances. Then at the end, defense counsel says, I've discussed with my client. He's aware that we could leave the record open, but we declined to do so. And from my opinion, that is the correct strategy because I've extracted everything that I hope to gain through cross-examination of the state's expert. On the major premise, the idea that Roby requires expert testimony from both sides, I don't think that's what Roby says. What Roby says to me is that it's the state that we presume, we have a default rule that mitigation is warranted, that a minimum sentence is not warranted in most cases. To overcome that, to show that the mitigating weight is diminished to a level where it's no longer meaningfully mitigating for culpability, such that a minimum would be warranted, that takes expert testimony, expert evidence, analyzing the applicability of the factors to this particular situation.
I think all that's 100% correct. But let me ask you this question. So you have the colloquy up front, and then the court, as I characterize it, gives a second opportunity. I don't know if you'd characterize it the same way, but kind of says, makes it the second offer. What does the record show as to any kind of communications that occurred at that point between the client and the lawyer, if anything?
Well, the record, it's a transcript only reflecting things that were said. So if there was consultation in the room, that's not on the record. The defendant, I believe, gives his statement about the sentence directly after that happens. So if the defendant had any, I think the defendant's free to speak about whatever thoughts he has about the sentencing at that point. And honestly, he was unequivocal earlier on when he said he wanted no more continuances. I think it's clear that when the opportunity comes up, do you want a continuance? He's already expressed his opinion on that. I really want to my goal here is to kind of give you an idea of what I think these sentencing hearings look like in light of Roby and all the other cases. The way I see it is the court is still statutorily obligated to consider all relevant facts, circumstances, victim impact statements. Just like in the 902.1 context, some facts about the offense are going to be aggravating. The court must consider them. My suggestion is that the court should consider all facts about the offense as though we're doing a regular sentencing hearing. Consider those first and talk about everything relevant about the offense. Then say, we are sentencing a juvenile. We're going to apply Lyle and Roby. We're going to consider, that would be the end of the story if this were an adult. Now we're going to talk about the unique ways in which youth mitigates culpability and see if those principles are applicable in this particular case to significantly mitigate culpability. Usually they do. We're going to analyze the factors and see if they do in this case. And then if the analysis shows that that normal mitigating weight is not applicable in this case, if there's just not as much mitigating weight as you would normally see, that may show that a minimum is warranted.
Shouldn't it be just the opposite? I mean, I understand your two-step process, but shouldn't the first question, I mean, there's a presumption, I gather, that mandatory minimums don't apply. Shouldn't the first question be, well, what are the mitigating factors, and does he fall within the scope of the presumption A, and then go on to B? I mean,
this court's free to say that
would it
if you
matter?
want to. The reason I think that the other approach works better is because, I mean, what we've always been told is courts are cautioned not to let facts about the offense, potentially aggravating circumstances, overwhelm the analysis. So whatever you analyze last, I think, before the sentencing decision, I think you can view as having the greater impact on the ultimate sentencing decision reached. I feel like it might give the wrong message to do a Lyle analysis and talk about mitigation and then talk about the crime scene and the impact on the victims.
If I heard you correctly, Mr. Sloven, what you're saying is what we're ultimately looking at, though, is culpability.
I think that's accurate. I think that's the lesson of Lyle and Roby.
I mean, one could argue, one could take a different view that what we're looking at is what's the minimum time that's going to be required for the juvenile defendant to be rehabilitated. That's another approach that I arguably find some support in language from Lyle and Roby in cases like that.
I mean, I agree that some of the language says that, especially the quotes from Coker v. Georgia, I believe, about meaningless, needless imposition of pain and suffering. I strenuously disagree with that being the guiding factor in the approach. I think the reason that we have the 5 Lyle and Miller factors, they all look at things that might diminish the culpability of the offender at the time of the offense, right? We talk about how the offense was committed. Is there peer pressure, substance abuse? We talk about infirmities of youth, the things we know about young, juveniles' decision-making that may have rendered this juvenile less culpable. And we do consider rehabilitation. I think that's relevant for the rehabilitative justification and incapacitation rationales. But the primary focus of the Lyle and Miller inquiry is whether youth mitigates culpability.
But the whole purpose of not sending somebody for a mandatory minimum, and we can go to life in prison without parole too, is that at some point in time, they may be at a place where their brain has sufficiently developed, they understand what they did, they understand what they did wrong, they can be rehabilitated and let out and shouldn't be held in longer than that period of time, and that's life without parole. The same thing should apply to these youths who are mandatory minimums. If the court can see that over this time before the mandatory minimum period is up, that they can reach the same goal, it appears to me that's what the court should be looking at, rather than, he's 15 days before 18 and things like that.
I mean, I agree to a certain extent, but the problem is that sentencing is not entirely a pragmatic exercise. There's a retributive element to it too. And yeah, retribution generally weighs less heavily when we're talking about juveniles. At the same time, youth is a mitigating factor, not an excuse. That if a person has, engaged in this cold cognition, sat down at the drawing board and planned out a violent attack on others and made the conscious decision to pursue that objective, and the culpability there requires retribution, regardless of if they won't do it tomorrow.
That's the U.S. Supreme Court analogist. They're incorrigible. I mean, if they're incorrigible, you get life in prison without parole. If it's a murder. But if they're not incorrigible, I think you got to look at something else.
I'm not talking about incorrigibility, though. I'm not even talking. This is true regardless. Even if you can get 100% guarantee that they will never commit another violent crime in their life, the fact of the offense, the fact that it was committed, triggers a retributive interest that we have to punish the crime, not just because of the harm on the victims, but because of the transgression against society.
But the parole board could take that in consideration when they don't grant parole.
The parole board can never take retribution into consideration.
But the parole board will not grant parole until they have their services, and the prisons don't give services. I mean, that's a fact of life in Iowa.
But again, that's not about the retributive interest that I'm talking about. That's about a rehabilitative interest, which I agree with you is something that we consider, and we consider it under Factor 5 of Lyle. It's important, but it's not the only interest. And if the facts of the offense, if you analyze Lyle and find youth-related mitigation of culpability isn't present here the way that it usually is in juvenile criminal offenses, that you don't have a reason to walk away from that strong retributive interest that is present when you see a crime like this.
Now, can I ask you one question? And I don't want it to be a springboard to larger discussion, but we have two separate movies playing here, if you read the briefs, right? I mean, for example, if I can repackage and recharacterize what the defendant is saying, well, he was a loner, his family sold chickens, they made fun of him, et cetera, drug user, ... And yet your viewpoint, I think it's fair to say, is nothing really remarkable about kind of family circumstances or this youthful isolation theory is something you do not subscribe to at a minimum. What is it? My first question, I guess, is what does the record show on what I'll call the loner making fun of me about chickens, use of drugs, et cetera? That's the picture that's being painted by the defendant. What does the record show, in your view, on those issues? And I invite you to lead that into a more general discussion of why you have such different viewpoints of the record.
Sure. So on the use of drugs, I'll let Dr. Clemens' report speak on that. I think it's very clear. She lays out the reasons why these reports of a 10-day or 4-day methamphetamine binge are not credible. These are reports that still even surface in his February 2nd, 2018 version of the crime. That's confidential appendix page 68. When we talk about him being a loner and being made fun of, when we talk about family and home environment for the second Lyle factor, I don't know that I've ever seen a case where being picked on by one's peers or teased gets the kind of mitigating weight that we find significant under that factor. What we're usually looking for is like a broken home and that's just not what we have here. We have two supportive parents. We've got some discipline in his early life. I'd agree that that's there, and he had some back surgery, but by and large, he's looks like a loving family, and they've been with him every step of the way through this whole ordeal. And I wanted to get to the bigger discussion. It's a sentencing decision, and we're going to review it for abuse of discretion. I know that Roby lays some parameters around that, but ultimately in deciding what's credible, what's not, which of these two competing narratives accurately describes the records and the testimony and what I'm seeing here. Now, if it's clearly unreasonable, that might be one thing, but I think the sentencing court has to take those two competing narratives, say this one fits the best with what I'm seeing and what I'm reading, and I find this to be the most credible.
Let me get back to the sort of the big picture issue. Just one more question. I'm almost hearing kind of agreement between you and Mr. Bender that what the sentencing court is looking for before it imposes a mandatory minimum is adult-level culpability. Am I correct?
Yeah, and I think that on the age factor, I think that even Miller says one of the problems that Miller found with mandatory sentencing is that the 17-year-old and the 14-year-old receive identical sentences. And that's a recognition that you're going to sentence someone differently if they're 17 than if they're 14. I don't think there's anything wrong with that. The fact that Mr. Majors was 17 years, 50 weeks is uniquely relevant when you talk about his developmental stage. Now, I've cited some of the science. We've both read the Steinberg book. That by the time you get to 16 or 17, your logical reasoning facilities are generally, your abstract thought in a cold cognition context where you have time to engage that higher level processing.
Yes, but the emotional components are not developed. The science does say cognition generally. I mean, it's a general proposition.
Yeah, absolutely, and that's why it's circumstance dependent. And you look at the circumstances of the crime.
I agree with that too. But the science tells us that impetuosity and poor judgment and poor risk analysis and so forth and so on, the kind of the emotive aspects of personality development doesn't occur until much later.
Well, sure, and even adult defendants, I mean, we see people make bad decisions all the time. The point that I'm trying to make is that when you're looking at the science surrounding juvenile offenders, you need to draw a distinction between those who are at about 16 or 17 and those who are younger and not quite at that developmental stage. And you also draw a distinction between those whose crimes are committed, surrounded by factors that trigger that decision-making track you're talking about, that more emotional, hot-blooded judgment. You've got peer pressure, actual substance abuse, which I don't think is present in this case. You've got time pressures. Those are the kind of factors where you could say the science supports youth-related mitigation of culpability because what we know about how uniquely bad juveniles' brains are in those contexts. But in this context, where he has time to outfit himself with the mask, the machete, the tape, the gun, the homemade silencer, observing over a course of weeks.
Ask about another thing. I agree that we've said you apply an abusive discretion standard once there's an actual hearing on the factors. The district court's decision strikes me as pretty solid, with one significant exception that struck me at least, and that exception is he seems to rely a lot on the competency evaluation that found Mr. Majors competent to stand trial. Is that really relevant at all to the issues that we're talking about adult level culpability?
The finding itself that he's competent to stand trial, I agree with you that that's a low standard, that isn't itself so relevant. I think it is correct to use those records because they are the best we have. They're a contemporaneous psychological screening and profile. The finding itself that he's competent to stand trial at least means that he clears a low bar. I think the meat of those records is more important in establishing that. I see my time's expired.
Could I?
You can answer the question.
Could I ask one?
You sure can.
So could you address the qualifications of Dr. Clemens and opposing counsel's criticism of the shortcomings of her investigation?
Sure. I didn't see any of those criticisms of her qualifications really come out below. I think that to tie it into your question, Justice Mansfield, I got three things to say. The first ties in. The first is that she reviewed contemporaneous records from contemporaneous competency evaluations. At the time, there wasn't a reason to do a Lyle hearing, or Lyle profile, I guess, if you want to make up the term. Lyle didn't exist. But those are the best evidence that did exist, or that does exist, of his then existing mental state and mental capacity. And she reviewed those as any expert would. Second, she demonstrated a working familiarity with the psychological and developmental science. I think that everything she said is true and is adequately, not just adequately, but well supported in the scientific literature. And three, she explained the basis for her conclusions. If there are problems with her qualifications, I mean, I don't find anything objectionable or incorrect about her conclusions, and I don't think there is anything incorrect to find. I think she reviewed the evidence, the best evidence there was, and made the.
Is there an Iowa Supreme Court case that recognizes an ineffective assistance of counsel claim where the client or the defendant himself made the choice?
I'm not aware of any.
And is the fact that Mr. Majors made that choice himself here at age 33 fatal to his getting relief on a claim that his lawyer should have hired an expert that he chose not to hire?
I think that's accurate, and even if a claim could survive about ineffective for making a certain recommendation, he would have to show prejudice in terms of what an expert would have said, and that's just not knowable on this record. Thank you.
Thank you very much. Is there any rebuttal?
Yes, Your Honor. May it please the Court. I do want to go back and clarify something with Justice McDonald with respect to when I talk about age, how I think that's important. I think if we look at what Roby has stated, I think that's the reason why I emphasize age. And I'm not trying to be inconsistent with what I stated in my brief. I think if you look at it in Roby, we stated that the age of the offender and features of the youthful offender is the basis for the core constitutional protections we have here. And the Roby court then recognized that the factor draws upon the features expected to be exhibited by youthful offenders that support mitigation and allows for introduction of evidence of the sentencing to show the offender had more or less maturity, whether or not they have deliberation of thought and appreciation of risk-taking than normally exhibited by juveniles. I think then that kind of correlates into what Justice Mansfield was asking with respect to culpability. Are we looking at adult culpability, as or rehabilitation? And I think that's the reason why age is important. If they have adult culpability, then they're not treated as a juvenile offender under the juvenile resentencing, then a mandatory minimum should be imposed. But the record here clearly shows that Mr. Majors, he had less maturity. He didn't have the deliberation of thought like we would expect, and the appreciative risk-taking normally exhibited by juveniles. Mr. Majors has low IQ. He has lower academic abilities. Goes back to what you were asking with respect to, is Mr. Majors just a loner? The evidence clearly shows he was physically abused by his father. This is not a rosy relationship as the state is trying to portray. He had medical issues when he was young that caused him to be loner. He had school issues. He had peers that were making fun of him. He stated he was diagnosed shortly after this incident with a mental issue. Then clearly he was saying he was having hallucinations. This is all in exhibit number 23 in the confidential appendix with respect to the DOC records. If you review all those records, it shows.
Well, we'll review them all, of course, but it seems fair to say that the expert, at least the state's expert, didn't buy in, at least. I mean, we discussed a little bit about drug usage with Mr. Sloven, and the expert basically said, well, I don't find that credible for this reason or that reason. To what extent does the state's expert undermine what you found in Exhibit 23?
Well, I think that's where I go back and talk about her qualifications. I think if you look at Dr. Clemens, I don't know Dr. Clemens personally. I'm going based on what the record was presented and on what she did before this hearing. And I think if you look at what her experience is, I think that's the key. She's looking at it through adult lenses. And I think that's key here. I think we keep going back to that because I think that's is very significant. If you have an expert who has no, experience with juveniles, and when they're presented, well, I'm using drugs, well, I don't believe you. Well, as we all know, criminals lie, and they, that's just the idea. But, juveniles, they're unique. And I was fortunate when I was a trial attorney, I did juvenile and adult work. And I think until you do that, you don't appreciate the idea of best interest of the child, why we do that in juvenile court. Because their juvenile behaviors they exhibit, even at age 16, 17, and I would even say 18, 19, if it is an immaturity, there is pressures there that we may not think is significant. They might say things that we might not think is true. But that doesn't mean that what they're not saying is true. She came to the conclusion, I don't believe him. But that does not make it that what he is saying is not true, that he was using drugs, he was drinking. That's what the record shows. The PSI reported that's what he was saying.
Now, but let me ask you this, if you don't mind, Mr. Bender. We have a somewhat odd standard of review, it seems to me. Maybe it's not odd, but we characterize it as abuse of discretion.
Kind of.
Yeah, well, that's my point. I agree with that, kind of. There's a presumption against mandatory minimum sentences. There are some instructions regarding mitigating factors. But at the end of the day, when there's factual disputes, to what extent do we defer to the sentencing court on factual resolution? I characterize it as two different movies. I'm kind of sticking with it, reading the briefs, but it seems like the district court basically rejected your movie.
Well, I don't even know if they even acknowledged that movie. I think that's the problem we have here. When we're doing this abuse of discretion, how much deference we should give to them. If you can't acknowledge these factors, and when they have to acknowledge these factors, that's the thing, these specific facts, because that's what we have stated, that you're supposed to look at these ideas with these family circumstances, this age circumstance. When you're not given that presumption initially, then the deference shouldn't be there, because you're not doing what you're told that you're supposed to do. If you're looking at it as aggravated, not as mitigating, that's where the deference does not apply.
I think you're making your client sound like a purple one-eyed monster that nobody's ever seen. I think we can assume in district court, and in this case in particular, based on the record, that, yeah, he was a youth at the time the offense was committed, 15 days shy of being an adult. But I think that the choices that your client made, such as not having the expert, I think is threshold to this whole argument, because I do, as Justice Mansfield said, I think there's a pretty darn good record by the district court judge as to why he ruled the way. You don't like the outcome, but he commented on a lot of those different topics individually, spent quite a bit of time. So I beg to differ with you that it's because he's a youth in and of itself, just because he said something isn't true. But I think we need to give the judge more deference than you're suggesting.
But the same token, if we are mandating that the court does a specific procedure, and that's how we're arguing. There's two issues here. One, whether or not he should have an expert, and whether or not the court erred when they resentenced Mr. Majors. Two different things. And I think when we look at it here, this court provided a specific mandate previously. They told the court what to do. The court did provide a analysis, a very a lengthy ruling in this case. But if the court does not follow what this court has previously stated that it must follow and must recognize, then I don't care how long that ruling is, it's still wrong. So, yes, the court could have emphasized certain things, but at the end of the day, they could still get the wrong analysis and still get the wrong decision. And that's what we're emphasizing here. The court undertook the wrong analysis. At the end of the day, Your Honors, we ask that you vacate Mr. Majors' sentence and remand for a resentencing. Thank you.
State versus Majors is now considered submitted, and we'll hear the next oral argument, Thornton versus American Interstate Insurance Company.